Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. The time after a dementia diagnosis can be filled with much stress and uncertainty as you look for answers and solutions for your family and future. Having an estate plan is not a cure, but it can hopefully bring your family peace of mind during a difficult time. But how and when do you start planning? Attorney Bob Mannor will be discussing this and more on today's webinar. Before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. If you have a general question during today's presentation, we encourage you to use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent tomorrow so that you can share the video with family, with your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. And with that, I'd like to welcome Attorney Bob Mannor.
Folks, we're going to get right into this here. And so one of the big questions that I get a lot of times is, okay, so we've got this dementia diagnosis. Is it too late? Is it too late to plan? And the answer is absolutely not. Obviously, it's better to plan early, and it's better to make sure that we have the proper legal documentation in place ahead of time. But honestly, it's never too late to plan. So we're going to talk a little bit about that in a few minutes, and we're going to talk about what it takes to do the planning and things like that. But the key on this is that the planning that you would need once you have a dementia diagnosis is going to be different than your standard estate planning. This is very important. So a lot of people assume they're fine and that they don't need to see a lawyer because they have a power of attorney or they have a trust or they have, you know, that type of a thing. And the reality is that it's more to that. There's more to it when we have a dementia diagnosis that we've got to think about than your standard estate plan, your standard powers of attorney, your standard healthcare proxy, your standard trust. We need more than that. We need it to be more specific than that. And this is very important because even if you went to a lot of lawyers, they're going to do the standard planning that you've done, even if you were perfectly healthy and there was no dementia diagnosis. So it's real important to find an attorney like us that focuses on this, that helps folks and has helped hundreds of families deal with this diagnosis and deal with the planning associated with that. I've had lots of times where folks would come in and they had just recently been to an attorney, and the attorney basically did, Savannah, it looks like we have somebody that's having some trouble hearing, so I don't know if you could maybe email her or try to get her some information about being able to hear the presentation.
Yes,
I assume
absolutely.
You can hear me okay?
Yep, I can hear you just fine.
Okay, good. So the idea here is that a lot of attorneys this is not their practice area. This is not something they do. And so I always joke about, if you went to your eye doctor and asked about your foot, they may have an opinion, but they might not have it be, it might not be the same as a foot doctor, right? And so, an attorney with experience in this area dealing with dementia is going to have significantly different advice than your standard wills and trust attorney, your standard power of attorney, your standard probate or guardianship attorney. Often, in fact, they're going to do things that work against what I would recommend. So if their recommendation is to go get a guardianship because you've got this dementia diagnosis and it's to go get a guardianship, that is not going to be my advice. In fact, I'm going to recommend against that in most cases. But a lot of attorneys, that's going to be their first line of advice. Oh, we got a dementia diagnosis, let's go get a guardianship from the court. I really think that's often a bad idea. That's often actually going to cause more trouble than it's worth here. So the advice that you're going to get from a standard attorney or even a really qualified estate planning attorney, a really qualified probate attorney, is going to be different than one that has significant experience in dealing with dementia. But the time to plan is now. If there is a dementia diagnosis, no matter how far along that dementia is, that time to plan is definitely going to be now. So I have this that I thought was something to point out here, as far as the we have this chart down here that I think is interesting and kind of goes through the different types of dementia. It's actually really helpful to know what type of dementia it is. So if it is the Alzheimer's, a lot of people just assume, some people even kind of use Alzheimer's as a synonym for dementia. But if it's Alzheimer's versus vascular, we kind of want to know that. That's actually would be helpful information. I was talking to a family today, and we were looking at getting some veterans benefits, and I said, the diagnosis is going to be really important when we're talking about that. Sometimes when people go in and they have dementia, the doctors are a little bit dismissing of that. They say, well, it's dementia, so why do we care what kind of dementia it is? Well, I think it's important because we're going to have different experiences. We're going to prepare for different things. And so really, I would want to dig down further to say what type of dementia it is. But then I really like these quotes that I found that I think are really relevant to this conversation. It's never too late to plan, but it's just as it's never too early to plan. So it's never too late to plan, but it's never too early to plan. So ideally, you plan before you get dementia, the diagnosis of dementia. But certainly, if you get the diagnosis of dementia, it's we likely are going to have to do additional or different planning. And so even for our clients, we may have done planning for you, estate planning. We might have done a will or a trust. If you get a diagnosis of dementia, I want to hear about that. I want to have a conversation with you. I want to see if there's anything that we need to change and update. And honestly, we've incorporated some things in your regular planning before the diagnosis of dementia that would help with this. We always typically incorporate it with most people's planning. However, I still want to know, and we may want to make some changes. So then I particularly like this other quote here that says, it's never too late to start and it's always too late to wait. So it's kind of the same thing. It's never too late to start, it's always too late to wait. The bottom line is, certainly once we have a dementia diagnosis, we need to have this consultation to kind of talk about what the future is going to bring, kind of talk about being prepared for the future. What if we can't handle it on our own anymore? What if we can't provide the care for our spouse or our parent on our own? They can't be completely independent. We can't just rely on family members. Even if we are relying on family members, what does that look like? Is there any legal issues associated with it? And I'll tell you, there's some surprising ones associated with, even if we just have family member help associated with it. There's some surprising legal issues associated with that. But also kind of planning for the future. Too many people wait to that crisis to come in and see me, and really you'd be so much better off, you'd sleep better at night if you knew there was a plan in place to say what would happen if we need to go into memory care, assisted living, nursing home, we need home care. How are we going to pay for that? How are we going to, is our financial set up properly? Is our legal planning set up properly? And you can potentially sleep a lot better at night knowing that we have that plan and saying, okay, when it comes to that time, we know what we're going to do. So even though I had a friend of mine talk to me the other day, we were at a baseball game, and he came up to me and he told me about this family that he'd been working with, and he said, well, his wife is already in a nursing home. There's probably nothing you can do at this point, right? No, it's never too late to plan. It's going to be easier for you to plan in advance. You're going to get a better benefit. We're going to be able to protect more if you plan in advance. But even in that situation where somebody's already in a nursing home, it's never too late to plan, just as it's never too early. Just as it's always better. So it's never too late to start, but it's always too late to wait. In other words, once we have that diagnosis, let's get our head wrapped around this. And here's the really interesting thing I find about when folks come in to see me. They've done their own research. They've talked to a number of people. They've talked to a social worker. They talked to a nurse. They talked to people that give them information about different benefit programs and different, analysis. But almost always, they tell me that I'm telling them information they hadn't realized before, or they hadn't been able to think through, or it's sometimes different than what other people have told them, because my perspective is going to be much more holistic. In other words, a social worker or a nurse at the hospital, a discharge planner, somebody that works at a nursing home, they're going to have context. They're going to have some context of what they've seen and what people have done. But I'm going to have a little different context. I'm an outsider. I'm not a social worker. I don't work at a nursing home. I don't work at a hospital. So I can take a perspective different than that. And often, a lot of the things that I'm going to tell you are going to be more specific and more detailed, and really there's going to be more options available than what you get word of mouth, what you get from a friend, what you get from even an experienced social worker or somebody like that. Because I can take it from the standpoint of, yes, this is how it usually works, but it doesn't have to work that way. So a lot of things, once you know the law, once you know what the rules are with regard to Medicare and Medicaid and veterans benefits and all these different programs, Michigan Waiver, Michigan PACE, all these different programs, they may know about those programs, but once you know the law, sometimes we actually can get better results than if than taking it down well, this is what usually happens. Because what usually happens is usually not the best. Often people are kind of moved around into different decisions without knowing what their legal rights are and their legal options. So it's always best to get onto a plan that is where you're getting it from a reliable source that's going to be able to give you the instruction. So that's my first point. I've labored on about this a bit, but my first point is it's never too late to plan, but it's also never too early to plan. In other words, once you know about us, once you know about that there's a dementia diagnosis, even if you've done legal planning with us before, it's a good idea to come in and we'll have another consultation on that. One of the big things that there's a confusion about is whether or not the person, spouse, mom or dad, whoever it is, the person who has the dementia diagnosis, whether they can participate in the planning. So frequently what we'll have people say is, well, there's no way that they can sign legal documents because what happened is we've already gone to the doctor and the doctor's already declared them incompetent. So does that mean that they can't sign legal documents? If they've never done legal planning, so I see this frequently, that people haven't done legal planning or their legal planning isn't sufficient, which is the vast majority of estate planning is not sufficient when there's a dementia diagnosis. We need more thorough, more detailed, specific legal documents for dementia. And your standard power of attorney and your standard trust are not sufficient for this purpose. So the first thing we look at is, can we have them sign updated documents? Can we add language to their documents that's going to provide more options, could provide better options for the family to be able to make decisions for them in a way that's going to help them protect their assets, help them get a better quality of life. And so the big question now is capacity versus competency. Because if you have a doctor declare the person incompetent, that actually doesn't mean that they're not able to sign legal documents. I think that there's a lot of confusion on this and a lot of people overlap those. And so, we've even been in care facilities where we went in to sign legal documents and the nurse objected and said, no, you can't sign those documents. This person's been declared incompetent. And then I have to explain to the nurse and I say, look, there's a different legal standard than there is the medical standard. So let me see if I can break that down for you a little bit. What is the legal standard? The legal standard is, do they have the capacity to say who they want help from? Do they still have that legal capacity to understand their surroundings enough to say, well, I don't want a stranger making my financial decisions. I don't want this to have to go to a judge and have a judge to make that decision. I want my oldest daughter. I want my youngest son. I want this person. This is the person I trust to make these decisions. Do they have that capacity? Versus competency. So competency is, can they balance their checkbook? Can they pay their bills? Are they making good decisions? Are they able to follow instructions 1 through 5? I think one of the standard elements of dementia is if you give somebody with dementia instructions, you give them 1 instruction, they might be able to follow it. You give them 5 instructions, they're not going to be able to follow those 5 steps. They might be able to get the first step done, but if you give them 5 steps, they might have forgotten the first step by the time that you give them the 5th step. So competency, are they able to balance their checkbook? Are they able to make rational decisions? Do they have executive decision-making authority? That's what the doctor's looking at as to whether or not they're still able to make these decisions for themselves and be in charge of their finances and things like that. But that's different than capacity to say whether or not they still have some impact on how their life is. In other words, do they have the ability to say, well, yeah, maybe I can't manage my checkbook anymore. Maybe I can't balance my checkbook anymore. But what I can do is say that this is the person that I want to do that for me. And if they have that capacity, the mental ability to make that decision, then often, not always, but often, we can still sign new legal documents and avoid having to go to court, avoid having to get guardianship, which now we're in the court system. Now the government has some say in how your life is run, okay? And we have to report back, or sometimes it's going to be appointed as a third party, somebody that's not a family member. And so the idea of capacity really boils down to 3 things. Do they recognize their family? If I ask you to name your family and you can't name your family, you can't identify your family, then you don't have capacity, you can't sign legal documents. Do you recognize your assets? Who owns the house that you live in? Where's your bank account? Who owns that bank account? Do you understand the concept of money? Understand the concept of money, you recognize your family, then there's just a 3rd element. Do you have a basic understanding of what it is that you're signing? So for example, a power of attorney. What's a basic understanding of a power of attorney? You're appointing your daughter to make these decisions for you. You're appointing your daughter to be able to go to the bank for you. You trust her to be able to pay your bills and access your bank account. And you trust her so much that you're willing to give her the authority to write checks for you and things like that. That's capacity. Do you understand that? Do you understand that's what you're signing? Now, we're not going to ask yes or no questions. We got to make sure that they understand it. They're not just nodding their head or something like that. But the idea is, do you have the capacity to recognize your family, to recognize your assets, and have a basic understanding of what it is you're signing? Then you likely have capacity. Though sometimes we still don't sign those documents if there's a big family fight and everybody's arguing and things like that. Then maybe we have to go in and get guardianship because of the family fights. But everybody's in agreement, everybody's really intending the right thing for mom or dad or spouse or whatever it is, and they have that minimal capacity, even if they're not competent to balance their checkbook, they still probably have capacity to say who they want to do that for them. So that's a really important issue when it comes to dementia. And then, I've kind of talked about this a little bit already, but estate planning versus dementia planning. Estate planning is going to be very different than dementia planning, okay? So some people will think, okay, Bob, I don't need to come see you because I went to the UAW lawyer, 10 years ago, 20 years ago, 30 years ago. I went to a really good, talented estate planning attorney last week, whatever it is. And my point on it is there's a difference between getting a power of attorney and getting a trust or getting a will, and somebody that really has an understanding and focuses on planning specifically for clients that have dementia. I've had many people come in where, and I'm going to give you a couple examples in a minute here, but where they went to a very talented and experienced estate planning attorney. They told them that they had dementia. The estate planning attorney understood the difference between capacity and competency, and they were able to have them sign new documents. But I look at the documents and I say, well, this isn't really ideal for a patient with dementia. We need to change this. And they say, well, wait a second, why didn't that other attorney, tell me this? And it's the bottom line is it's experience. Do you work with, is this a thing that you work with patients with dementia a lot? Patients, I said patients, I meant clients, but the example would be, again, going back to that, if you go to the eye doctor and ask about your foot, your eye doctor probably has some opinions about your foot, but it's not going to be the same as going to a foot doctor, going to a podiatrist. So it's something that you really have to take into mind. And you may have really good estate planning, but it's still something that you're going to want to make sure that we have somebody that has experience in this. Okay. So what else? So I like to talk about this from the standpoint of the elder care continuum. So from we start off with, everything's fine, there's no functional limits, to, going along and having more and more functional limits. Now that could be physical limits, or it could be memory issues, it could be dementia. And so the function is defined, in lots of different ways. And then we have to look at, where are we getting that care? Where are we living? Where are we receiving that care? And then, of course, we have to look at the cost of care. And then we have to look at, what are the sources for payment. Obviously, if you have unlimited finances, then you can pay for it yourself. But most of us are going to have to look at veterans benefits, different community services, Social Security, pension, family caregivers, and Medicare and Medicaid. And so that's what we can kind of help you sort through all of that to say, okay, where on this chart are we for functioning? Where are we and where should we be from the standpoint of where we're receiving that care and how we're receiving that care? How is it going? What's it going to cost, and how are we going to pay for this? So this is my artistic rendering here. I wrote this myself, and it's where I got this information from was a very talented doctor that specializes in dementia. And he showed me this, and I thought it was really, really very interesting. So I kind of drew it out for you. I'm not much of an artist, though. So it's function over time, right? So lack of function, lack of memory, ability to make decisions for ourselves, and ability to live alone, ability not to be supervised at all times over time. And so probably the most common form of dementia is Alzheimer's. And for Alzheimer's dementia, we kind of just expect this slow decline, right? We expect a slow decline, but it is always going to decline, and there's no cure. So, but then we look at another form of dementia. So one of the second most common form of dementia is vascular dementia. And vascular dementia, the reason why I'd like to know the difference, the diagnosis, whether it's Alzheimer's, a lot of times we get this diagnosis of general dementia. Well, that doesn't help me very much from planning for the future. And so I want to know, when we're planning for the future, is with vascular dementia, you could have a slow decline and it looks like Alzheimer's, but then all of a sudden a deep drop. And overnight, there somehow is a deep drop in functionality, and then a slow decline, another deep drop, and a slow decline, another cliff, and then a slow decline, another cliff. Why is it important that they're helpful, at least, to know the difference? Well, because if we have vascular dementia, we've got to plan for the idea that it's not going to be where, okay, well, it'll be a gradual decline and we'll plan over time here. It could be that, hey, we might need, in a short notice, we might need to change our caregiving schedule. We might need to change where they get the care, what the circumstances are overnight, because there could be a deep drop in their functionality very quickly. And then I threw this other one on here. Frequently we'll get calls to say, mom or dad or spouse, they were experiencing a lot of memory loss, but generally okay. And then overnight, they don't even recognize me anymore. They don't even understand, they can't form a sentence. It's just, it's gotten so bad overnight. Now, is that possible that could be a regular form of dementia? Yes, but it's rare that it's that big of a drop that quickly. And typically what that is some kind of body infection. The most common one would be a urinary tract infection. So when somebody says they went from almost zero dementia to 100% dementia overnight, my answer is, did they check for a urinary tract infection? Did they check for any other body infections? And the good news on that is, if we treat the infection, then sometimes they can make a significant improvement. Unlike these other ones where there really is no improvement, they're not going to have the upswing again. With a UTI or other body infection, often that can be treated, and this would actually be referred to as delirium because of the UTI, and we have to make sure they get their treatment. But once we know that that's an issue, then we have to, still do the planning for that, because you could have Alzheimer's and have a UTI, you could have, any form of dementia and have a UTI, and we got to plan for the idea that something could change dramatically in short notice. Some people always say, okay, when do we know that we have to act? Well, first of all, it depends on what you mean by act. First act is let's make sure their legal planning is in order, and we should do that now. And I'm not trying to pressure you, I'm just saying we should do that now. We can't put off legal planning because we don't know when they're not going to be capable. Remember that capacity versus competency? Well, there could be a point where they don't have that capacity and they can't do the legal planning, and now we're going to be stuck in the court system. And I can still do it. That's why I say it's never too late, because I can still do it, but it's going to be more difficult. It's going to be more costly. It's going to be more difficult for the family. And so that we shouldn't wait till we see these behaviors. But sometimes people will say, well, I think everything's fine. Mom can take care of dad, dad can take care of mom, or mom can still live alone, whatever it is. But if we see any of these things, my answer is we really have to take a look at making a change in their caregiving, whether it be going into memory care, assisted living, or nursing home, or getting care in the home, or moving in with family, whatever it is, we probably have to make a change if we experience any of these. Wandering, they've wandered away, even if it's in a grocery store. So they didn't wander far, but they wandered away. They could have been confused. They went down to get the mail and they ended up 2 blocks away. So wandering away. Aggressive behavior. I see this so often, and we have a husband and wife, and one of them has aggressive behavior. And you think about it, is it surprising if you don't have the memory and you wake up and you see this strange person that you don't recognize in your house? Wouldn't you be aggressive if you were in your house, or worse, in your bed, and someone else is in your bed with you that you don't recognize, or even just in the house with you? Wouldn't you have aggressive behavior? So it's not surprising that there's aggressive behavior. But once we have that, we probably need to make some kind of a change, right? We probably need to change the caregiving up in some fashion, whether it be to, whatever level of care. And we're going to talk about levels of care in a second. And then, of course, the trifecta here: falling, fall risk, dehydration, bed sores. If the person's getting bed sores, that's a sure sign that we need to change up their caregiving setting. If the person's going to the hospital for dehydration or malnutrition, something like that, that's a sure sign we need to change up their caregiving. And then falling, that's difficult to prevent, but we probably, if there's consistent falls and that's causing problems, we probably need to change up their caregiving and figure out something different, even if it's just bringing in caregivers or maybe looking at assisted living, independent living, things like that. So I found this chart I thought was quite interesting that goes through and talks about the different, cost versus level of care, supervision, and shows the range, the range of cost versus the range of level of care, starting out with, senior apartments, adult daycare, independent living, retirement community, respite care, assisted living, personal home care, dementia care, nursing home, hospice care. The one thing that I think is not 100% accurate here is this one that says in-home senior care. So the thing I don't think is accurate about that it starts off where in-home senior care can be low cost, right, on this chart, on this side, low cost, and then it goes up to about the middle. Well, the reality is home care can be from low cost up to the highest of costs. I have folks that are paying for home care and paying, $15,000 to $20,000 a month for home care. I have folks that are paying very little for home care. So when it says home care is on the lower end, yes, it can absolutely be on the lower end, or it also can be the most expensive type of care. And so, we'll often hear people say, well, it's best because they already own their home, they've paid off their home, that's going to be the cheapest to bring them into the home. That's often not the case, because when somebody comes into your home, most of the companies that do that say, well, we're going to have a minimum of 4 hours, we're going to have a minimum of 3 hours, and if we need round-the-clock care, that's going to be very expensive. There's lots of rules with regard to home care now, even changes in the last few years about wage and hour laws. So back recently, not too long ago, about, I'm going to say 6 or 7 years ago, they changed the rules, because it used to be that home care workers were exempt from some of the things. So if you need somebody to be with you, and even if they're sleeping, so let's say they stay in the home with you and they're sleeping, you still have to pay them hourly for that, and you have to pay them overtime for that. And so it became, under the new federal regulations with regard to wage and hour, it became close to impossible to pay one person to just live with you. And because legally, under the IRS rules and under the federal rules, you're supposed to be paying them for every hour that they're providing care. So if they have to get up in the middle of the night to help you to the bathroom, we have to pay them even if they're sleeping, even if they're watching TV, even if they're, whatever, and we have to pay them overtime. So what it usually becomes now is, now we have 3 shifts of people that would come in if we're paying for 24-hour care. So that can get very expensive. So, and not everybody follows those federal regulations, but that's what the IRS says, and that's what the federal wage and hour laws say. It used to be that home care was exempt from those federal wage and hour laws, and several years ago they changed that so that it is no longer exempt. This is a chart that we came up with in our office, and I think this is very helpful from the standpoint of, once we decide the level of care. So as you see on the left-hand side here, the different levels of care: home and independent, home with care, independent living, adult foster care, assisted living, and so on. And then you scroll across, kind of tells you a little bit more about the different levels of care, and under, you can look at it and see what kind of caregivers are there, how are they licensed, is there 24-hour care, medical care, is it locked to prevent wandering, can it be paid for by the VA, is it going to be paid for by Medicare or Blue Cross or your health insurance? And then the last 3 columns, how does it participate with Medicaid PACE, Medicaid waiver, and Medicaid nursing home? And so it's important to look at this chart from the standpoint of, well, first we got to kind of decide what care we need, what level of care we need, and then we can look at what form of payment we're going to use. This is sounds backwards, because most people come to me and a lot of people come to me and they say, well, we want veterans benefits, or they come to me and they say, we want Medicaid. And what I have to do, the first step I have with my clients, is to say, okay, great, but let's talk about what veterans benefits will get you. Let's talk about what Medicaid will get you. And then we have to decide, because we need to know the level of care before we're going to be able to determine what program we're going to use. And that's really important. So the first step is a family decision of what level of care we need. It's partly a medical decision, but partly a family decision. So often we'll see people come in and they'll say, well, we're going to get care in our home, I'm still going to live alone, and we're going to bring in care. And then once I explain the options to them, they just assume that, oh wait, we'll get Medicaid and that'll pay for it. Well, Medicaid doesn't pay for 24-hour care in the home. I mean, in theory it could, but very, very rarely does it. And so we've got to look at it and say, all right, well, we've got to look at our options and say, where are we going to receive that care? Because we also have to look at what options we're going to have for paying for that care. All right, so the next thing here, we have something that we do typically a little bit different than a estate planning attorney. I was mentioning earlier that our legal planning is often going to be a little different if we have a dementia diagnosis, or even frankly different than just your regular estate planning documents. So one of the ways that our legal documents are different than your standard power of attorney, your standard trust, is we include these things called extraordinary powers. What is the extraordinary power? Well, a lot of times what we need is flexibility. We need you to have somebody who could do the planning for veterans benefits, the planning for Medicaid, the planning for different programs out there, PACE and waiver and different other programs, but you have to pre-authorize that. You have to make sure that you have someone that you love and trust, that you trust them to make these decisions for you regarding your finances. Now, that sounds a heck of a lot like a power of attorney or a trust, doesn't it? Well, the thing is, most powers of attorneys have restrictions on what the person that you appoint can do. And even if it doesn't specifically have those restrictions, which most of them do, the state of Michigan has specifically said, there's an attorney general's decision from several years ago that said that even if it's silent, then they write those restrictions in for you. So sometimes people will say, well, I can just have a power of attorney that says my daughter can do anything I can do. And the state of Michigan says, but they can't do that. They can't do this. And the state of Michigan does have an option that says, unless you specifically authorize it. So saying they can do anything I can do is not good enough. So having a very broad, general, very few word legal document is not good enough. We actually have to give that specific authority, which we call extraordinary powers, to be able to protect assets for Medicaid, be able to transfer assets, to be able to do the things necessary to build in that flexibility. So that's one of the reasons why our legal documents are often different than your standard power of attorney, your standard trust, your standard estate planning documents. All right, so then this is a very important one. Often we'll have a married couple where one spouse is what I call the caregiver spouse, and the other spouse is the one that has dementia. And so why is that different? Well, I see all the time people will go to their lawyer and they'll get legal documents, power of attorney, all of that, and the lawyer writes up the legal documents exactly the way that they would have had the person not had dementia. And that's absolutely not going to be the best answer here. So if we have a spouse with dementia and a caregiver spouse, we definitely are going to want to redo the legal documents for a variety of reasons. First of all, we got to make sure the spouse with dementia is not listed as the person who's going to make decisions for the healthy spouse, the caregiver spouse. Secondly, we've got to make sure there's a plan in place, a different plan in place for if the caregiver spouse dies first. Because the vast majority of time, when you go to an estate planning attorney, what's it going to say? When one of us die, everything goes to the surviving spouse. Well, if the surviving spouse has dementia, Alzheimer's, Parkinson's, Lewy body dementia, vascular dementia, any of these things, then that's not actually the best plan. It would be better to set it up so that those assets are protected, and there's a way to do it so that we could, if the caregiver spouse dies first, we can set it up so that the assets are protected from a Medicaid spend down. We're going to make sure that they're managed properly, that it's not having to be managed by somebody that has dementia, that it's completely different planning, and it's not intuitive at all. Okay, so it is something that we have to do separate, new planning once we've got this diagnosis of dementia and we have a married couple. Because we don't want, if the caregiver spouse dies first, we don't want everything just to land in the ownership of the spouse with dementia and not have it protected, not have a clarity as to how it's going to be managed and how bills are going to be paid and all of those types of things. So this is really, really important, and we typically make significant changes in that situation where we have got a married couple where one spouse was diagnosed with dementia. Now we need to vary from the standard estate planning practices. Okay. All right. So I want to jump forward and say, what can we do? With planning, what can we do? Well, I'm going to focus mostly on Medicaid planning. So Medicaid is going to be any of those three programs. Medicaid Waiver, which is the home care program, Medicaid PACE, which is the program for all-inclusive care for the elderly, and Medicaid Nursing Home, in case somebody needs to go into nursing home. Well, most of the time when someone says the word Medicaid, I'll hear people say, well, that means you're going to lose everything. You're going to lose everything if you need to get on Medicaid. Well, that doesn't have to be the case, as long as we've completed proper planning. So, and what did I say earlier? When do you need to do the planning? Well, the best answer is now. Do the planning now. The second best answer is whenever you do it, because it's never too early or too late to do the planning for dementia. But if we needed Medicaid in that situation where we have a married couple, look at this. There's safe harbors that are hidden in the law that are very rarely used. So most of the time, if you're told that that your spouse has dementia and you need Medicaid, often you're going to be told you got to spend down to next to nothing. Sometimes people tell you got to spend down to half of your assets. What I'm telling you is most of the time, we can protect 100% of the assets in favor of the healthy spouse. 100%. So if you're doing a spend down, you got to call us today. You got to call us right now. If you're doing a spend down, we need to change that, especially if you're a married couple. If you're a single person, sometimes we can protect up to 100%, but typically we can protect at least 50%. So 50% and up, depending on the circumstances, but not just 50%. We can protect the house, a car, and about 50% of the other assets. All right, that might be different than what you heard about Medicaid, because most people heard about Medicaid, you got to spend down to $2,000 and all of that. Medicaid is different than Medicare. Remember, Medicare is what you have for hospital and doctor and things like that. Medicaid is what can pay if you needed Medicaid home care, Medicaid PACE, or Medicaid nursing home. And so for a married couple, we can typically protect 100%. For a single person, we can protect somewhere between 50% and 100%. The alternative is have to spend down to $2,000. Are you ready? So this goes back to our very first conversation: is when is the time to plan? And honestly, the time to plan is now. If you're worried about this type of long-term care planning, you're worried about dementia, you should plan now. We need to get some basic things in place ahead of time, those extraordinary powers, for example. If you have a diagnosis, absolutely the time is now. Ideally, it's before you lose that capacity versus competency, right? So ideally, you're coming in before you lose that capacity. And since we don't know when capacity could be lost because of a UTI, because of vascular dementia, because of all these different things, it could be overnight. It doesn't, have to happen that way. But the idea is to do the planning now. There's no reason to wait. And so but if you have waited too long and you're worried that maybe they don't have capacity and that we wouldn't be able to sign legal documents, we have alternative plans. They're not as easy. It's going to cost more, but we have alternative plans, even if you think it's too late. It's honestly never too late. So are you ready? The answer is, if you're worried about this stuff, if you're attending this webinar, the answer is now. You're ready. You should be. We need to make sure we have these things in place. And I rarely am this pushy about things, but when it comes to dementia, I gotta be pushy, because it's gonna be so much easier if we plan early. We plan now versus plan when the crisis hits. We plan after the crisis hits. It's so much easier if we have some basic planning in place first. When I say basic planning, that doesn't just mean basic powers of attorney and basic trust. So the time to plan is now, or the time to plan is, at any time. In other words, it's never too late. But what we can provide, a lot of what we've been talking about is the finances, how we're going to pay for it, right? So we can provide the help of how we're going to pay for it and look for the different programs that will pay for it. But we also provide support and advice and guidance. One of the things is there's just so much here. There's so many different options. Are we going to be able to get care in the home? What if we have to go to assisted living? What if we have to go to nursing home? And we can walk you through all those and help you make decisions. That's a big part of what we do. We have this the Care Now plan is what we call it, and the Care Now plan is where we will support you and help you through the decision making. And so, of course, we're going to talk about finances, and of course, we're going to talk about legal documents and making sure you have the control and access and the ability to stable things out. But one of the things we also will help you with is making those family decisions and kind of walking you through the options so that you have a better way of making those family decisions. So if you have questions, now would be the time to ask those questions. And also, Savannah is going to tell you how to get follow-up questions. So my advice, if you're here and you're worried about dementia, or you have somebody that is been diagnosed with dementia, or even if it's a pre-diagnosis, but you're pretty sure there's dementia, this is as good a time as any to come in and get a consultation and find out what options you have, okay? So Savannah's going to step in and talk to you about how to get more information and how to get an appointment with our office, which I would strongly recommend that if there's a dementia diagnosis, you do that sooner than later.
Thanks, Bob, and thanks everyone else for joining us today. As Bob mentioned, we do have easy ways for you to get in touch with our team, whether you want to talk about someone who's been recently diagnosed with dementia and make a plan, or maybe Bob said something else today that sparked you. Maybe you need a power of attorney or anything. We're here. Let's talk. So you can always give us a call. Our phone number is 1-800-990-6030. You can also, if you're not available to call now, or you're just like, I don't know if I have time, I've got a way for you to actually choose a day and time that our team can call you. And in the chat, I've just put a link. When you open the link, it'll take you to a calendar, and you'll just choose a day and a time that works for you, and a member of our team will reach out to you then. You can ask us questions about our firm. We'll also ask questions about your situation, and then we'll just take it from there. Make sure that you get the planning that you need. So again, you can call us 1-800-990-6030. or you can click that link. I'm sending you an email as well. You may already have it in your inbox. That link and our phone number will be in the email. And then tomorrow, I'm going to send you a replay of today's presentation. So again, I encourage you to share that presentation with family or with your friends or anybody who you think could benefit from hearing this information. And our contact details will be there as well. Thank you again for joining us, and we look forward to seeing you again next week.